On July 16, 2021, U.S. District Judge Andrew Hanen of the U.S. District Court for the Southern District of Texas issued a decision in the case of Texas versus the United States. Judge Hanen found that DACA, Deferred Action for Childhood Arrivals, was unlawful. He therefore issued an injunction, which prevented the Biden administration from accepting any new applications under DACA. President Biden vowed to appeal the decision. However, this administration is unlikely to overturn the district court's decision on appeal. And in this video, I will explain why. My name is William Kovatch, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media. Although it's not always their fault, immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. Let's start off with a brief background of what DACA is. DACA, Deferred Action for Childhood Arrivals. This is the program that was announced by President Barack Obama in June of 2012. And then it began with the issuance of specific rules by USCIS in August of 2012. Basically, DACA is a promise that the U.S. government would not seek the removal of dreamers. Dreamers being those young people who were brought to the United States by their parents while they were young, who had no choice in the matter of coming to the United States, who were undocumented and therefore had no legal immigration status, but who were raised in the United States and came to think of America as their home. Now, DACA did not grant legal status. It was only a promise not to seek the removal of people who qualified for the program. But in addition, those who qualified could apply for a work permit, also known as an EAD, Employment Authorization Document. That's the ID card that shows that a person who is an alien or a person who is not a U.S. citizen has the legal right to work in the United States. Now, millions of young people who were brought to the United States as children have been able to take advantage of DACA, and it's been a popular program. It has allowed a number of these children to come out of the shadows, to accept jobs, to buy houses, to go to school, to join the military. Everything except vote and do other things that citizens can do. In fact, as DACA is not a legal status and just a promise, people who are DACA recipients can never become citizens of the United States. It was a program that was popular not only among DACA recipients, but also among Americans, native-born Americans, as many of these native-born Americans were able to see that DACA recipients are good people, people who are hard workers and are dedicated to having good lives and trying to go to school and raise a family in the United States. It was popular among members of Congress. Many members of Congress have said publicly how they support DACA and how they want DACA to continue. However, the program was placed in jeopardy when Donald Trump was elected president. On the campaign trail, Trump promised that he was going to do away with DACA. And while he seemed to flip-flop on the issue once he came into office, the fact is that his first Attorney General, Jeff Sessions, then attempted to terminate the program. There was litigation over that attempt to terminate the program. And this is where the Supreme Court found that the way that the Trump administration went about in its attempt to terminate DACA was unlawful. But understand, the Supreme Court was not asked whether DACA itself was unlawful or unconstitutional. And because of that, the Supreme Court has never said directly whether it found DACA to be lawful or unconstitutional. Then in May of 2018, a number of states, led primarily by Texas, they filed a lawsuit in the U.S. District Court for the Southern District of Texas, where they directly challenged for the first time the legality and the constitutionality of DACA. Texas and a number of other states that supported Texas argued that DACA was unlawful. They argued that it violated the Administrative Procedures Act, or the APA. They also argued that DACA was unconstitutional. They said it was a violation of the Take Care Clause in Article 2 of the Constitution. Now, both sides filed cross motions for summary judgment. What this means is that both sides said that the evidence was not really in dispute, that there was no genuine issue of material fact with respect to many of the issues, and that the court could make a decision without holding a trial. And on July 16, 2021, Judge Hanen issued his decision. He granted the motion for summary judgment in part for the state of Texas and the other plaintiff states. Now, if you read the decision, there are a number of technical legal issues that I'm not going to get into here. There are issues like whether the states even had standing to sue. I'll leave that for somebody who is more of an expert in civil procedure to address. But much of Judge Hanen's decision on the legality of DACA rests on an understanding of the Administrative Procedures Act. So, let me briefly go over what the Administrative Procedures Act, or the APA, is here. So at the heart of the DACA dispute is our constitutional principle of separation of powers. This is the idea that our government is separated into three separate branches, and each of those branches have their specific role. The legislature is that branch, that is Congress, that passes the law. They make the rules. The administration, the executive, well, they're the branch that administers the law. They enforce the law. And then we have the courts. The court's job is to resolve disputes under the law. And while they're doing that, they interpret the law and whether the law fits under the Constitution. Now, over the course of the 20th century, what we saw was this development of more and more complex legislation. We would have legislation that created these large, complex programs. And Congress understood that these programs were going to be administered by experts who worked for the executive branch. They were going to be administered by administrative agencies, bureaucrats, who were trained and had more experience in the specific subject matter. So what Congress would do is they would pass these programs with broad policy goals and broad policy ideals. And then they would leave it up to the executive branch, to the specific administrative agency, to make the very specific rules on how the program would operate. They would do this by issuing regulations. But of course, that would give an awful lot of power to the executive branch, and that power would need to be checked. So to address this, Congress passed the Administrative Procedures Act. The point of the Administrative Procedures Act is to make those rules that address how the executive branch makes its regulations. Now, there are many purposes behind the APA. It is meant to be a method of transparency, a method by which the government shows the public how it reaches its decisions. It is meant to encourage public participation in rulemaking. It's supposed to allow the public to comment on proposed rules and give their views on whether or not this is a wise thing for the government to do. It is also meant to create a more uniform process for how the executive branch creates its rules. And the role of the courts under the APA is to determine whether an administrative action in creating the rules is really arbitrary and capricious, or an abuse of its discretion. That is, an action that is not otherwise in accordance with the law as passed by Congress. Now, the big requirement of the APA is something called notice and comment. That is, the public must be given notice of a proposed rule and must have an opportunity to comment on it before it becomes final. And before the executive branch issues its final rule, it is required to take the public's comments into consideration. Now, typically, this is done through the Federal Register. The Federal Register is that publication that comes from the U.S. government where Everything that the government does is published. The administration that is making the rules will publish its proposed rules in a notice in the Federal Register. And it will tell the public, okay, we are now accepting comments on these proposed rules. It will give a deadline. This is when you need to comment by. It'll give an address or a way that the public is allowed to comment. And then the administrative agency that has published the proposed rules, it must take those comments and take them into consideration, read them, and consider what it is that members of the public are expressing concern over. Once the administrative agency is ready to issue its final rule, it must address those comments made by the public. And so you'll have another publication, another notice in the Federal Register. It's usually a fairly long notice where it goes through either the types of comments it received, if those comments can be categorized, or maybe the specific comments that it received, and addressing them, why the comments either are not a big deal or why the comments indeed led to changes in the final rule. And in this way, the administrative agency is required to make a reasoned decision. So the first issue for the court in Texas versus United States is whether the Obama administration violated the APA when it created DACA. That's because USCIS did not publish a proposed rule concerning DACA in the Federal Register. Instead, the president one day announced, I'm going to implement DACA. 2 months later, the rules came out, published on the USCIS website. The U.S. government argued that notice and comment was not necessary because DACA was not a general rule. However, Judge Hanen noted Fifth Circuit law. Now, the U.S. District Court for the Southern District of Texas, it lies in the Fifth Circuit. And let me take a step back. And the U.S. Courts of Appeal are divided into 13 circuits. 12 of those circuits are determined by geography. For example, I live and work in Virginia. Virginia is part of the Fourth Circuit. If you lived and work in, say, Pennsylvania, your court would be the Third Circuit, as the Third Circuit addresses Pennsylvania, New Jersey, and Delaware. Well, the Fifth Circuit addresses a number of southern states that includes Texas. So the U.S. District Court for the Southern District of Texas lies in the Fifth Circuit. That means that when a judge issues a decision, the judge must consider case law from the Fifth Circuit in making his decision. And Judge Hanen, well, he addressed Fifth Circuit law. And he said that under the Fifth Circuit precedent, a general statement of policy is not one that finally determines a matter. Rather, a general statement of policy is one that leaves open the door in any particular case to the discretion of whoever the decision maker is, depending on the specific facts and circumstances, to make that decision. So it's like a general idea. This is generally how we want a case to be decided, but on these facts and circumstances, you, the decision maker, you decide that you want to take this action. Well, Judge Hanen noted that in DACA, it created a set of criteria that was used to determine whether somebody was eligible for the program. And because this set of criteria was being used without weighing discretion. I mean, that is, you had things like you had to come into the country by a certain time. You had to have been a certain age when you came in. You had to be below a certain age when you applied. You had to show a degree of physical presence in the United States. Because we had all these specific requirements, then DACA was doing more than simply creating a general statement of policy. It was deciding the case. It was criteria that was being used that constrained, if you will, the discretion of the specific decision maker in determining whether to grant DACA. Moreover, DACA did more than merely postpone a decision to remove an individual who otherwise had no legal status from the United States. And just to step back, what is deferred action? Deferred action is the authority of the president to choose not to enforce immigration law by not seeking the removal of somebody who they otherwise believe is in the country illegally. And Judge Hanen said, well, DACA does more than that. It does more than simply promise an individual that we're not going to seek your removal from the United States. Rather, it conferred on people benefits such as work authorization, so long as they met a certain criteria of eligibility. Specifically, somebody who received DACA, a DACA recipient, had the right to get a work permit or an EAD, employment authorization document, and consequentially a right to participate in programs like Social Security and Medicare, because Social Security and Medicare taxes could then be taken out of the DACA recipient's paycheck, much like anyone else who lives and works in the United States. Moreover, the fixed criteria of DACA meant that there was very little by way of discretion that was being exercised when somebody who was reviewing the application was deciding whether or not to grant DACA benefits. So given these fixed criteria and given the level of rights, Judge Hanen said that DACA was not a general statement of policy, but instead it was a genuine rule. And therefore, as a rule, it was subject to the notice and comment requirements of the APA, or to put it more succinctly, because it created a rule that the administration, the Obama administration, was required to give the public notice of the proposed rule and give the public an opportunity to comment. Because the Obama administration did not do that, then he found DACA, that is, Judge Hanen found DACA was not lawful, that it was a violation of APA procedures. Regarding the substantive claims pursuant to the APA, Judge Hanen noted that an administrative agency has no power to act, except that which is conferred on it by Congress. That is, an administrative agency can't act on its own. It must be created and have a mission given to it through legislation passed by Congress. And that is that Congress, through legislation, gives the administrative agency its life. It gives the agency its purpose, and it sets its authority, its limits on what it can do. An act of an administrative agency may be held illegal if that act exceeds the authority that was given to it by Congress. In this regard, Judge Hanen noted that Congress had already passed an expansive scheme that regulated how immigration benefits were given and to whom. That scheme was through the Immigration and Nationality Act, otherwise known as the INA. In this case, Congress had not explicitly given USCIS the authority to create and implement DACA. Moreover, when Congress addressed the problem that DACA sought to solve, and that is the problem of the young people who were brought to the United States without any input of their own, Congress repeatedly failed to pass the DREAM Act. And so, Judge Hanen held that the executive branch could not just enact its own legislative agenda whenever it agreed with congressional inaction on an issue. That is, if Congress fails to act, that doesn't give the executive branch the authority to act in its place. When Congress had explicitly created a specific, detailed, and comprehensive scheme that addressed immigration benefits, the administration was not free to supplement that scheme with its own methods. And that, Judge Hanen said, is exactly what the administration did when it implemented DACA. Judge Hanen went on to cite an explicit example of how DACA violates the will of Congress. And specifically, this is through the use of advanced parole in order to gain permanent residency for an alien who was otherwise ineligible. Now, advanced parole is basically permission to leave the country and come back to the United States with the same legal status, although I use that word loosely since DACA did not really confer any legal status, but the same legal situation that a person was in before they left the country. And as I stated, DACA just did not create a legal immigration status, but DACA did grant recipients the limited ability to apply for advanced parole. That is, DACA recipients were able to ask for permission to go overseas on a limited basis and come back to the United States and still maintain their status as a DACA recipient. Now, if we add to this situation a process known as adjustment of status. Adjustment of status is where an alien has the ability to apply for a visa right away in order to become a permanent resident. That is, an alien may have come into the country legally as, say, a tourist or a student, and then something happened. Maybe they married a U.S. citizen. And since things changed, as a spouse of a U.S. citizen, they are now able to apply for immediate relative status. And as an immediate relative, they have a visa immediately available that allows them to become a permanent resident. Now, normally when you file a visa petition, a person has to return to their home country in order to process through the consulate in their home country to become that permanent resident. However, in some circumstances, if the person is present in the United States, they can get permission to stay in the United States and adjust their status. Adjustment of status. Now, by statute, adjustment of status is only open to an alien who has been inspected and admitted to the United States legally. However, the language of the statute also says that those who have been paroled into the United States may also apply for adjustment of status. As I said, the normal case is a situation where you have somebody who entered on a temporary visa. Usually that's somebody who entered as a student or entered as a tourist, or may have entered as a temporary employee, and then something changed in their status. Maybe they married a U.S. citizen, maybe they got a job that entitled them to become a permanent resident. Normally speaking, an undocumented alien who has snuck across the border without a visa, they're ineligible for adjustment of status even if they married a U.S. citizen. But the catch is, since the statute allows for an alien either to have been inspected and admitted or paroled into the country, well then a person who has gained advanced parole may apply for adjustment of status. What this means is if you have a DACA recipient who married a U.S. citizen and then went overseas after applying for and receiving advanced parole, well, they're able to come back to the United States, reassume their status as a DACA recipient, and then apply for adjustment of status and become a permanent resident. This, Judge Hanen saw as a major exception to what Congress intended when it passed the Immigration and Nationality Act. That is, in a way, DACA allowed for certain aliens to do an end run around the statute in order to become a permanent resident, even if that particular alien came in the country undocumented. Judge Hanen found that this was a specific example of how DACA violated the will of Congress. Thus, because through DACA, the Obama administration exceeded its authority as granted by Congress through the Immigration and Nationality Act, DACA was unlawful pursuant to the APA. Finally, Texas and the other states argued that DACA was unconstitutional because it violated the Take Care Clause. Now, what that means, Article 2 of the Constitution sets out the duties and the responsibilities of the executive branch, specifically of the president. And Article 2 provides that the president must take care that the laws of the country are faithfully executed. The argument here being that by creating DACA and allowing otherwise undocumented aliens to remain in the country without pursuing their removal, the president was failing to take care that the laws concerning the removal of undocumented aliens was being faithfully executed. On this argument, Judge Hanen declined to issue a ruling, and that's because he had already found that DACA was unlawful pursuant to the Administrative Procedures Act, so he didn't need to address the constitutional issue in order to dispose of the case or controversy. But now let's add to this situation the fact that we have a Supreme Court case entitled The Department of Homeland Security versus the Regents of the University of California. There, the Supreme Court held that the Trump administration failed to properly terminate DACA. Now, we are going to get into the details of that case in about 2 weeks, but in light of that Supreme Court case, Judge Hanen did not order that the administration was to stop implementing DACA. That is, Judge Hanen did not say to the administration that the DACA program in and of itself had to come to an end. Instead, he only issued an injunction which prevented new applications from being considered and granted. Now, President Biden has vowed to appeal, but there are some problems with this. You see, as we've already discussed, the Southern District of Texas sits in the Fifth Circuit, and the Fifth Circuit has already had litigation that addressed a similar program. That was the Deferred Action for Parents of Americans, or DAPA. And the Fifth Circuit found that program to be unlawful under similar circumstances on similar grounds. We're going to address the DAPA case next week. So, given that we already have this Fifth Circuit case that is out there and is precedent, that is, it is binding on the Southern District of Texas, well, it's unlikely that if the Biden administration appeals this decision and it goes to the Fifth Circuit, that the Biden administration is going to win. Plus, we now have a Supreme Court that is split 6-3 between conservative and liberal justices. In this situation, it is highly unlikely that once the Fifth Circuit affirms the decision of the Southern District of Texas, that the Supreme Court is going to step in and then reverse the Fifth Circuit. What this means is that in the end, the crux of Judge Hanen's decision that DACA is unlawful is likely to remain intact, which means that DACA will still be considered unlawful, and no new applicants will be permitted to be accepted. But for now, current DACA recipients appear to be safe, but no new DACA recipients will be allowed in order to benefit, and the program will not likely be expanded. Thus, so long as we have an administration, like the Biden administration, that does not try to revisit the termination of DACA, current DACA recipients are probably safe. They probably will not lose their benefits of being able to stay in the United States and being able to work in the United States legally. That is, there's probably not an immediate threat that such recipients are going to be placed in removal proceedings. Will that continue to be the case? Well, that depends. One of the main things it depends on is whether or not we continue to elect Democrats in the White House. If we have a Republican administration, there is a chance that that administration will attempt to revisit the termination of DACA, except taking into consideration the Regents of the University of California case, and do it properly this time. Which ties us back to the point that I made in the video last week, which is that DACA is bad policy, because there's always going to be hanging overhead this threat that one day DACA will go away and the people who have received DACA will be deported. So anyway, now it's your turn. Tell me what you think of this situation. Leave your comments below. Also, give this video a like. Tell your friends about us. And don't forget to subscribe so you don't miss another video like this in the future. In particular, next week, we are going to talk about the DAPA program and the litigation over the DAPA program. Thank you so much for watching. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.